Cardozo has 4 methods. The first method is the method of philosophy, and this is where the judge applies the Constitution or statute to a case, and it ensures justice and logic are upheld.
The second method is history. It is basically the history makes the path of logic clear. Some conceptions of the law exist in their current form solely because of history, and that's about it for that.
The method of tradition or customs is less than it meant before now. We took the custom for the test and standards that determine how established rules are applied. And we don't look to it so much for the creation of new laws, but we look to it to extend older laws and change them and evolve them from what they used to be.
The method of sociology is used when judges are considering the welfare of society. Mostly the demands of society are that a judge makes a decision within his narrow bounds, and they must search for social justice.
Okay, the first case was Roe versus Wade, and that took up the position of whether abortion should be illegal or not. They issued the decision that abortion is a fundamental right of someone if it is medically necessary. Roe versus Wade was a case that Blackman used the method of sociology, which concerned an abortion. Blackman was forced to consider the welfare of society in the case because of the issue of abortion. The ruling was that a woman may have an abortion in the case of the well-being of the baby or the mother. Depending on how far along the pregnancy is, the matter becomes increasingly important or less important. That's because longer in the trimesters is worse if the baby is aborted or not. Blackman decided in favor of social justice that a woman is not able to get an abortion without justified reasoning. Sociology is one of Cardozo's methods used in this case, and it is applied because he was looking for the well-being of prenatal life without putting society in the position to abort needlessly. The welfare of society extended an existing rule to look out for the society as a whole.
And my case was Bowers versus Hardwick, in which he was charged with violating the Georgia statute of criminalizing sodomy. They challenged this because the sodomy was consensual. The issue at case was whether or not consensual homosexual sodomy is protected under the fundamental right of privacy. The court said no, and it's not protected under the fundamental right to privacy or even the U.S. Constitution. Blackman's dissent said the right to an individual to conduct intimate relationships in their own home seems to be the heart of the Constitution's protection of privacy. We also use the method of sociology in this case because Blackman is not entirely agreeing with the fact that it's the welfare of society, because what one does in their own home is not concerning what other people are doing outside, and it was also consensual. So it does not affect society at all.
Okay, the next case involves Schneck versus U.S. And in 1917, an Espionage Act was passed, which stated during the war, people obstructing the draft and trying to make soldiers not want to go to war was considered a crime. Schneck was against the war and mailed leaflets to young men, urging them to assert your rights and to not submit to intimidation. The government convicted Schneck of violating the Espionage Act, and basically Schneck disagreed and said the Espionage Act was unconstitutional because it violated his right to express his freedom of speech. And the decision by Justice Oliver Holmes claims that Schneck would have the right to say everything that he wanted in pamphlets. But on the other hand, how far a person's freedom of speech extends depends on the circumstances. The question in every case is whether the words are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has the right to prevent. According to Holmes, the pamphlets were printed with the intent to obstruct initiation efforts, an intent that was prohibited by federal law because it constituted clear and present danger.
My case is Debs versus United States. It was 1919. They had convicted him of insubordination for speech in the military. They said that the danger in this case was a very real threat, and he gave multiple speeches during his time in the military. Debs, the acknowledged leader of the American socialism, gained over 1 million votes while doing these. The Justice Holmes responded to Debs' constitutional argument by referring back to the Schneck versus United States, in which he had said that the danger was real and that he needed to be convicted, and he ended up being convicted and got 10 years for each speech that he gave out.
After Schneck and Debs came Gitlow versus New York in 1925, and Holmes had a dissenting opinion in this case. The case involved Benjamin Gitlow, and it was for the First Amendment, freedom of speech and press, and he's a socialist that developed a left-wing manifesto that was actually a newspaper, and it made a point to advocate violence and then overthrow the government. And the 14th Amendment prohibits states from infringing free speech, but the defendant was properly convicted under the New York criminal anarchy law. And he actually appealed to the Supreme Court, and Holmes, who is the author of Schneck's clear and present danger test, actually wrote that he believed it was still the appropriate test to employ in judging the limits of freedom of expression, but he argued that Gitlow presented no present danger because only a small minority of people shared the views and because it directed an uprising at some indefinite time in the future. And the court decided to use the bad tendency test.